Why do administrative courts often say they cannot decide constitutional questions? It's August 1st, 2026. Welcome to YesToHellWith.com. Have you ever noticed that when people appear before an administrative court or hearing officer, they often begin arguing about the Constitution? They cite the First Amendment, the Fourth, Fifth, Sixth Amendments, or they simply declare their constitutional rights have been violated. Then many times the hearing officer or the judge responds by saying something like, "I don't have authority to decide constitutional questions. Those issues are outside of the scope of the hearing, perhaps. Or, I'm here only to apply the law." Now, why is this? Does that mean that the Constitution doesn't apply? Of course not. The Constitution remains the supreme law of the land. So what is really happening? The answer begins with one of the most important questions in the Liberty Dialogue system, and that is authority. Every government official, every agency, department, tribunal, or court possesses only the authority that has been entrusted to it. That includes administrative tribunals. Most administrative hearing officers are not asked to decide whether a statute is constitutional. They are asked to administer the statute. That is a very different responsibility. Think about that for a moment. If a licensing board exists to determine whether someone complied with licensing regulations, its responsibility is generally to administer those regulations. If a zoning board exists to enforce zoning ordinances, its responsibility is generally to administer those ordinances. If an administrative tribunal exists to hear workers' compensation claims, its responsibility is generally limited to that. So notice the pattern. The tribunal has been entrusted with a particular function. That function is usually defined by the statute that created it. So when a hearing officer says, "I don't have authority to decide constitutional questions," that statement is often misunderstood. Many people hear, "The Constitution doesn't matter." That is not necessarily what is being said. The hearing officer may instead be saying, "The legislature has not entrusted me with the authority to invalidate the statute that I have been assigned to administer." Those are two completely different ideas, and that distinction is important. The Liberty Dialogue system teaches us not to stop there. Instead, we continue asking questions. If this tribunal cannot decide the constitutional issue, then who can? Must the constitutional question be raised here in order to preserve it? Must it later be presented to another tribunal or reviewing court? Does another court possess authority that this tribunal does not? Those are the Liberty Dialogue's questions. Notice what we're doing. We're not immediately arguing about constitutional rights. We're first asking about authority. Who possesses it? Who does not? What authority has been entrusted to this tribunal? What authority has been withheld? Only after reviewing those questions do we move to jurisdiction, and then status, standing, obligation, and enforcement. That sequence is critical. Most people begin with enforcement. They've received a citation. They've received a notice. Their license has been suspended. Their benefits have been denied. They're already reacting. The Liberty Dialogue system begins much earlier. It asks, who has the lawful authority to do what? That question often changes the entire discussion. Different tribunals have different responsibilities, different jurisdiction, procedures, and limits. The Liberty Dialogue system does not assume that every tribunal can answer every question. Instead, it seeks to understand the structure of the system before attempting to challenge it. And that understanding also affects the record that you build. If a tribunal lacks authority to decide a constitutional issue, that does not necessarily mean the issue disappears. It may still become part of your record. It may still become an issue for review later. It may still become significant in another forum that has been entrusted with broader authority. Again, that is why the Liberty Dialogue system places such an emphasis on establishing a superior record. The record preserves the questions. It preserves objections and issues. And ultimately, the record preserves your opportunity to continue pursuing a remedy where lawful authority exists to address it. The Liberty Dialogue system teaches us to understand government before attempting to persuade government. It teaches us to understand authority before arguing jurisdiction, jurisdiction before status, status before standing, standing before obligation, and obligation before enforcement. That discipline sequence changes the way we investigate. It changes the way we prepare and the way we think. And it certainly changes the record that we leave behind. Because sometimes the most important constitutional question is not simply, what are my rights? The most important question is, who has the lawful authority to decide this issue? Once you begin asking that question, you have already started thinking in the context of the Liberty Dialogue system. And that is the best start that you could have. And as always, may truth reign supreme.